All right, what's up, perps? So, let me give a little bit for everybody to get in here. Everybody see my bright smiling face? Well, I find my lighter, whatever I did with it. Wait for a couple of people to get in, and then we'll start this up. Today, I didn't realize it was happening, but I got to work and found out that the oral arguments challenging and defending Maryland's so-called shall issue scheme was challenged today. So, of course, I listened to it first time as soon as I found it this morning, but so this is a Fourth Circuit. That's what I thought. Yeah. What's up, 500? So yeah, it was challenged in the Fourth Circuit today. And I guess now what they're looking to do is to see whether this goes up the chain in the courts, whether it gets decided here or whether they kick it back down to the lower court. So, and I can't remember. I think the lower court might have upheld their scheme, and this is why it's made its way this far up the ladder. So we're going to see. But we got to start out with the traditionals. I mean, we got to do our thing here. In honor of Mike McClune.
Hey, boys, look what I got here.
Hey, where are the white women at?
Oh, man, we All right, let me get my big self back up here. What's up, Krabby Turtle? DJ, what's happening? All right, so the file we're going to look at, or what we're going to listen to, are the oral arguments that happened this morning. And you guys tell me when we actually get into this, start listening to it. You guys tell me who you think the judges are actually kind of leaning towards. All right, DJ. Let's see. Let me pull this up. I think it's here. It is. Yep.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez. All persons having any manner or form of business before the Honorable of the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Morning. Welcome to the Fourth Circuit. Please be seated. Judge Keenan, can you hear us all right?
Yes, I can, Judge Agee. Thank you.
All right. Good to see you. We're ready to have argument in our first case, Maryland shall issue versus Moore. Mr. Nardone, I'll be glad to hear from you.
Thank you, Your Honor. Good morning, Your Honors. I may it please the court. My name is Mark Nardone. I'm here today to argue on behalf of the plaintiffs and appellants in this case. At the outset, it is critical that we distinguish what is and is not at issue in this appeal. This appeal is not about the constitutionality of background checks. This appeal is not about the constitutionality of what may or may not be required of an individual seeking to carry a firearm in public. What this case is about is whether or not the government may require law-abiding, responsible citizens to obtain permission from the government to be able to undergo a background check that permits them to acquire a handgun. Your Honors, under the standard that was set forth in
Can I ask you that why are you going that far? Right? Because it seems like to me that your argument instead is that they can't do this, right? Which is a narrower question, right? You said it may require permission at all, but what they've done here is they're requiring permission after waiting 30 days.
It is, Your
And
Honor.
so it might well, at least help me understand, it might well look different if that permission was virtually instantaneous, right? So if there was a computerized background check that was done in some form or fashion that was virtually instantaneous, didn't require them to leave the store, for example, that might be a different constitutional problem than one that takes 30 days. Is that?
That's absolutely right, Your Honor.
Yeah, because Maryland could hang you up for 30 days. You have to get trained. You have to get fingerprinted. You have to get this license before you can even do a background check. So this license comes before the background check. Then you've got a waiting period, like a 7-day waiting period on top of that. There's all these different things in Maryland that could hang you up for months just trying to get your carry license. What's up, G23?
Honor, and it's also critical that the handgun qualification license, what is at issue in this case, does not allow an individual to acquire a handgun in Maryland. And that's why I think it's important to start with the statutory scheme here of what exactly occurs when a law-abiding citizen seeks to acquire a handgun in Maryland. In Maryland in 1966, enacted a law that required enhanced background checks for individuals who wish to purchase, at issue here, handguns. That involves the provision of a social security number,
No,
driver's
you're
license
100%
number,
right.
your address, all manner of identifying information. It requires a 7-day waiting period. And it also, as of 2000, required a viewing of a 1-hour video. All of that is still required. And that is the process that an individual who wishes to acquire a handgun needs to undergo. And that I believe,
Just so I understand, you have not yet challenged that requirement.
that has not been challenged, Your Honor. That is not at issue in this case whatsoever.
Yep,
At
Brandon.
issue is the law that was enacted in 2013. In 2013, this
So to be sure, I understand the factual context here. If I'm a citizen of Maryland and just suppose someone has threatened me or my family, and I want to obtain a handgun to defend myself in my own home, I have to wait the 7 days and then the 30 days, be fingerprinted, get the background check, pay the fee before I can obtain the firearm.
It's actually an even longer process than that, Your Honor. The way that it works in Maryland currently is that before you are able to file an application for a handgun qualification license, you are required to attend training that lasts a minimum of 4 hours and can only be conducted at a location that allows for the discharge of live ammunition, thus prohibiting in the major city in Maryland, Baltimore.
Who pays
any
for
training.
who pays for that?
That is paid for by the individual seeking the license, and the fee is set by the trainer. It is not set by statute. The discovery in this case indicated that the fees can range upwards of hundreds of dollars. After that training is completed, an individual receives a
And
certificate.
how available are those sites?
That would depend on the availability of the trainer themselves. So the way that it is statutorily set up is that individuals are qualified as handgun instructors. They then instruct at locations, and that is dependent on their
Hold on
schedule.
just a second, counsel. Rachel, we're not showing any time here.
Oh, it's up on the screen there, sir.
Oh, I got it. All right, thank you. My bad. Go ahead.
Of course, Your Honor. They are as available as the instructors are. Now, I will candidly admit, we do not have evidence in the record as to whether there are gaps, but we do know that there is an issue that individuals who are in Baltimore City, for example, cannot simply travel to a close by site for their training because they must go somewhere that permits them to discharge a firearm under the regulations adopted by the Maryland State Police.
So
As
what
part of
about
training.
what about the fingerprinting? Does the applicant have to pay for that?
They do, Your Honor, and that is also not a fee set by statute. The fingerprinting is also required before the handgun qualification license application can be submitted.
Where you do it?
You can do it at any one of the state's live scan vendors, which are all privately operated, and they can charge whatever fee that they wish.
Okay, Mr. Nardone?
Yes, Your Honor.
I'd like to consider your argument in the context of Justice Thomas's and Supreme Court's footnote number 9 in Bruin. And it seems to me that the court laid out a path for us to consider in terms of shall issue regimes. In other words, laws that have a narrow objective focus rather than the kind of discretion that was at play in Bruin, where the court would make you show just cause and the state could turn you down anyway. And so I think the Supreme Court in footnote 9 was saying that in the case of a shall issue regime, where the criteria are narrow and focused, that there isn't a problem unless there is a too lengthy waiting period or an exorbitant fee. The court seems to leave a kind of a catch phrase at the end saying that there can be conditions that make a shall issue law unconstitutional, even though shall issue laws generally will pass constitutional muster. So take us analytically through footnote 9 and with your argument. Is your argument solely then that these conditions are too exorbitant as to fee and too lengthy as to waiting period, and that's what renders it unconstitutional? And that if the waiting period was shorter and the fee was lesser, it would not be?
Your Honor, I think there's a few things there. I'm happy to address that. Number one is I think that the test that's set out in Bruin that must be applied in all Second Amendment cases, regardless of the manner in which the evaluation is to happen, is the text, history, and tradition test. And under that test,
Jason,
the
what's up, brother?
law is a novel attempt at addressing an old problem. It is unconstitutional if the challenge law could have been acted at the time of ratification. There's no question that had the government wished in 1791 to enact legislation that would require citizens to obtain permission before undergoing a background check, which establishes whether or not they are a permitted possessor, then they could have. And there is simply no historical tradition of that. But no, I would say does not go as far as to countenance all shall issue jurisdictions or statutes. Rather, it is an acknowledgement that what was at issue in Bruin was a particular problem, the problem of government discretion. And so there's that number 9.
And do we have government discretion here? Or do we simply have a waiting period that is too long, in your view, and a cost to qualify as too expensive?
Your Honor, I don't think it comes into the purview of footnote number 9 because we are not dealing with the same situation of licensing that we were dealing with in Bruin.
Exactly, and that's what footnote 9 is addressing. It's saying that although the court in the New York statute in Bruin was called to pass on a may issue statute, what the court is saying, nothing in this analysis shall cause us to question the.
See, if you listen to her, she's trying to shoehorn in Maryland's whole regulatory scheme. She's trying to shoehorn that into this footnote that says, there can be some regulation. And this doesn't fit there. And that's why the lawyer is arguing we don't even touch that in this case. We're going after these other sides of this.
The constitutionality of shall issue regimes unless they are exorbitant in fees. In fact, the court even says that fingerprinting requirements and background training are not a problem unless the fees are exorbitant and the waiting periods are excessive. I mean, the court very clearly in that footnote talks about fingerprinting and says that that's not a problem unless there are barriers imposed by the state. So it seems to me that based on this footnote, and tell me why this isn't correct if it isn't, but it seems to me like based on this footnote, there's a different kind of analysis that Bruin needs to be tweaked a little bit, because the majority opinion in Bruin dealt with a may issue regime. We have a shall issue. In other words, if you pass the background check and you pass the training, the state can't say you haven't shown just cause.
Just calling something shall issue doesn't make it shall issue. You fucking hag.
State's got to issue it.
Your Honor, I think
And so,
That's it.
so are you agreeing then that footnote 9 puts your argument in the category of saying that the fees are too much and impose too great a burden, and the waiting period is too long?
not at all, Your Honor. I'm saying that this case does not fit within that framework whatsoever, because the license that we are talking about is fundamentally different than the license that was at issue in Bruin. In Bruin,
Right, but I'm asking you about footnote 9. Footnote 9 is drawing the distinction with the majority holding in Bruin,
Your Honor,
and
the
talks
license,
about fingerprinting and talks about and talks about training.
Your Honor, the license-
And you haven't addressed footnote 9. Would you please address your argument in the context of footnote 9?
thank you, Your Honor. In Bruin, the license at issue allowed. the
Perhaps
individual-
another way to ask that question is footnote 9, a generic Second Amendment framework, or is footnote 9 directed to that case, which was a public carry case?
Your Honor, I think that it is different for a number of reasons.
That's well, if you want to scare you,
Obviously,
just start rubbing his belly going.
Licenses to carry and licenses to possess, because the interests that are at issue are different when you are carrying outside the home and versus not. However, we need to make clear that the license at issue in Bruin permits an individual to carry a firearm as soon as it is issued. And the license here is not that. That is why it is fundamentally different than what was at issue in Bruin. And that is why footnote number 9 does not have relevance to this particular case. What we are dealing with here is not a license that permits someone to acquire a firearm. If you have a handgun qualification license and you receive it in the mail on Monday morning, and you immediately go to your closest federal firearms licensee and you attempt to buy a handgun, you cannot do it. You cannot walk out of the store that day with that handgun. It is not the same license. Rather, what this license does is it permits an individual to undergo the background check that ostensibly determines whether or not they are permitted to acquire a firearm. And we know that because when one goes to purchase it, the provision of the handgun qualification license is insufficient to permit them to walk out the door with their handgun. And so, Your Honor, I don't think footnote number 9 here is controlling, but moreover, I think footnote number 9 is more narrow than that. I think what it is saying is that the issue before the court in Bruin was whether or not may issue licenses are permissible. And therefore, there is no reason for the court's decision to have had any impact on shall issue jurisdictions. I think that is all that footnote number 9 is saying. And at the end, it obviously allows for challenges where a shall issue jurisdiction could still violate the Second Amendment. I think that, Your Honors, is a recognition that regardless of whether this is a may or shall issue case, what the court needs to look at is the effect of the law. And whether or not the effect of the law is to impose an unconstitutional burden on the right to acquire a handgun. And in this case, like every other Second Amendment case, the mechanism by which that determination is made.
Now, what I was saying, I've lost the audio for a little bit. What I was saying is, yeah, you got to go through like 30 days to get this license, this firearms license. I guess it's like a firearms purchaser license. Then you got to go get training, which you can't get inside the city. You got to go outside. Like if you live in Baltimore, you got to find some place outside of there to drive to go get live fire training. Then you got to watch this 1 hour video. Then you have to apply for your carry license. God knows how long that's going to take. Then you go to buy your firearm. Then you have to wait another 7 days on top of that, I think, to get your firearm approved. And you got to have a state and federal background check. You got like a hula hoop on each arm, each leg, and your freaking waist trying to get through this.
Is evaluating the historical tradition of firearms ownership and the rights afforded by the Second Amendment. Your Honors, there is no historical analog, tradition, or anything related to the idea that an individual needs permission from the government to be allowed to undergo the background check that determines that they are in fact eligible to possess a firearm. This is akin to requiring a permit for a permit.
Mr. Nardone, briefly before you sit down, is your position that the different requirements of the statute are severable?
No, Your Honor, I don't think they are.
They have to rise and fall together, and why is that?
I think that the entire handgun qualification license scheme is in fact unconstitutional for the reasons that I said. It is not permissible to require, Your Honor, may I finish? I see my time is finished.
Go ahead, please.
It is not permissible to require an individual under the auspices of ensuring that they are not a prohibited person to first seek out permission from the government to be able to undergo that inquiry. That is what we are talking about here, and that vel non is unconstitutional. But the individual components, the fingerprinting, the class, those are unconstitutional in and of themselves because there is no historical tradition of those. But the entire statute itself is unconstitutional, Your Honor, yes.
Okay, and let me ask you just one other thing for you to consider on rebuttal. Should this case be remanded to the district court to make the determinations that you're asking a court to make today?
Your Honor, I'm happy to answer that now, but if you prefer, I can wait to rebuttal.
Go ahead. That way your opposing counsel can have the benefit.
Your Honor, no, I don't believe a remand here would be appropriate. We are dealing with a question that involves legislative, not adjudicated facts. This case was briefed after Bruen came down. The government was able to provide whatever citations to whatever sources that it felt was necessary to meet its burden under Bruen to demonstrate the constitutionality of this case. On remand, any issue would be under the same evidence that it would have presented here, and any appeal from that remand would be de novo by this court. I don't see any situation in which a remand would do anything other than waste judicial resources to arrive back here at the exact same posture that we are now. Your Honors, unless there are any other questions, I would reserve for rebuttal.
All right, you've got rebuttal time. Thank you, Mr. Dietrich.
Now, the dude for the state gets up now. And you guys tell me if you think this is a bloodbath, because I think it is.
Your Honor, may it please the court.
Can you start with the last two questions that Judge Keenan asked of your colleague? And the first being, who bears the burden to establish severance? Have you argued that this statute is severable? And if you haven't argued it, can you help us understand why we should consider a severance or severability argument at this particular stage? And then second, the question that Judge Keenan asked your colleague about remand. I noticed in your brief here, you did not ask for a remand. At no point did you request a remand. And it stands in stark contrast with the same brief or similar brief you filed in Bianchi within a week of this brief, where you did ask for a remand. And so I sort of take that as been a conscious choice to not ask for a remand, given the proximity of two briefs from Maryland, both addressing Second Amendment cases, both following Bruen. But wanted to give you a chance to comment on both of those.
I'll take the remand question first, which is that to the extent there's evidence necessary to resolve the question, I think it's in the brief and in the record below. There was discovery. There was no discovery in Bianchi. None of it.
No, I understand. I
It's
think
like that
that's
big
right.
rat
I just
snake.
wanted
He
to
didn't
make
want
sure
to come
that
out.
I wasn't missing something from your end.
Right, but your discovery was before the Bruen decision.
In this case, yes. Yes, it was.
So there would have been no reason to
I just got broke my fucking heart.
have elicited the information that Bruin would seem to require.
Maybe.
But I think we're talking about two different things.
I
possibly.
wonder if that big corn.
Bianchi, we're
rat
talking
snake was in
about
the barn
evidence of
went up.
the historical tradition
No!
at issue there, and whether there were
Dark
statutes that supported restrictions on types of weapons, and that was the.
And also the empirical question of whether these firearms were in themselves in common use. I mean, that's an empirical question that evidence had not been developed on in the record below.
That's correct, and their utility for self-defense and things of that nature that went to that historical tradition. Here, the discovery down below was about the whether this burden was onerous on the applicants.
Yeah, let the bloodbath begin.
What the evidence showed was that when we compared pre-HQL, pre-Firearm Safety Act of 2013, and post that act, we saw that people were getting handguns at a higher rate.
How does that relate to the Bruin standard?
It relates to the Bruin standard because, well, there's a few Bruin standards, I think, floating around here. The Bruin standard of history and tradition is one thing. The Bruin, what we'll call.
And you've got to cross that bridge first.
And I understand that. And
your brief seems quite sparse on historical analogs in the founding era.
the historical tradition here, I see, Judge, I'll answer your question.
No, please, I'm sorry. Answer Judge Agee's question first.
The historical tradition is the substantive limitations that are furthered by the HQL law. And those are ensuring that dangerous, subversive, non-virtuous, however you want to describe it, folks do not get deadly firearms,
No.
and ensuring that the tradition of firearm competency that was alive and well at the founding and before that.
What founding era analog do you have from any of the states that a citizen was required to have a permit from the government before they could have a handgun in their home?
The historical analogs relate to the substantive limitations that are part of the robust historical tradition.
Well, why don't you give us an example?
We look at laws from the founding that related to individuals who were required to take a loyalty oath.
This judge is going to slaughter this dude. He's talking about, oh, well, they're required to take a loyalty oath. But yeah, they had their guns. They didn't take their guns if they, said they were going to be loyal.
Or be disarmed at the time of the founding. We look at.
But that's after the fact, right? So that's, if you don't do something, we're going to take your gun from you, right? So for example, if you commit a felony, we will then require you to turn your guns in. All right, that's fine, but that's not pre-clearance, right?
No, and I understand that. If I could just get out that when I talk about two Bruin standards, the second Bruin standard is the one that's in footnote 9.
Right. So I want to go there. I still want you to come back and talk to me about whether you've tried to assert severability. But if you want to go to footnote 9, your argument, as I understand it, is that footnote 9 is an exception to Bruin's history and text test. Is that we don't have to look at history and tradition, that the whole opinion in Bruin carves out an exception in footnote 9 and says a different standard applies. Is that how you're asking us to read footnote 9?
No, it's not. How we're asking you to look at it is that we want you to look at history and tradition. Bruin commands us to do so. And that history and tradition is talking about how it's furthered
What's up, Waffles?
By the HQL license in respect to two historical traditions. One is restricting those who are dangerous or contrary to public safety from getting handguns. And two, a robust historical tradition of firearm competency and requiring responsible citizens to be trained in the use of firearms.
So what's that have to do with the analogs they talk about in Bruin? I'm still waiting for any remote founding era statute.
And this judge is like, yeah, give me something that fits into Bruin. You're talking about all this other bullshit. You can't cite a law. Give me something that fits. And this dude's just he's stepping all over his own tongue. And it's funny as shit.
That had a restriction similar to what we have.
And I understand your question.
Well,
Your
do
Honor.
you have one or not?
Do not have any, we were unable to find any that required advance permission. But when you look at what Bruin is saying, Bruin is giving us the roadmap in footnote 9 about what states are able to do vis-a-vis substantive
Separate
limitations.
from history. So in other words, you have no history, but this footnote which says this other case exists out here that's not before us, that you want us to apply that standard instead of the 50 pages of analysis that the court actually engages.
That judge just smacked the shit out of that dude.
Like skip the history and just use this exception to the Bruin test.
We are not saying it's an exception to the Bruin.
I think you are. I mean, I know you don't want to use that word because it's pejorative, right? Like I'm using it for that reason, but how is it not an exception if you're saying, yeah, we've got no history, but look at footnote 9, right? But look at footnote 9. It creates a different path, right?
Gotcha.
I think earlier it was referred to as a different analysis, right? Was the statement that was made. There's different analysis that's in footnote 9.
But the Bruin footnote 9 path requires history and tradition as a fundamental premise of the substantive limitations that are being addressed there. And I think that's the message that Justice Thomas, the majority in that case, and Justice Kavanaugh and the Chief Justice in the concurrence were saying that when you have substantive limitations, you can have procedural mechanisms to enforce them. That's what Judge Easterbrook said in the 7th.
Can you turn to the severability and just help me understand? Do you make the argument that the statute is severable? And do you agree that it's your burden to do so?
We didn't address severability in our briefing. Our position is that the law is constitutional as is because it is a regulatory scheme
But it rises or falls together.
I think that's
Mr.
Judge
Dietrich,
Cannon has a question.
yeah, Mr. Dietrich, you can't concede an issue of law as to severability. But I want to ask you a question about that.
Now this is the judge trying to get this shit to fit in that footnote. What's up, Vanessa? So she's going to try to get all of this crammed into that footnote 9, but it's not even being argued on that basis. So she is trying like hell to uphold it while the other two judges are just smacking the shit out of this dude.
It seems
Yeah.
to me that, and I think Judge Richardson makes a
Vanessa Kitty, the wife, said, hey,
really good point. The Supreme Court is not taking back the requirement of historical analysis. I suggest to you that what footnote 9 is doing is saying that in a case you have a shall issue regime and the criteria are narrow and objective, then you have to make a determination of infringement. The Second Amendment talks about infringement.
she said, hey,
And they
Mr.
didn't have to consider nuances of infringement in Bruin because the government controlled everything. It had complete discretion, so automatically there was per se infringement. But here, the issue in infringement has to be considered along with historical tradition. Seems to me that that's what they're saying. And if that's the case, and if evidence on remand shows that there is a historical basis for keeping dangerous people from having weapons, but there is no historical basis for requiring training of firearms, why wouldn't the statute be severable?
Your Honor, I just admit I'm not necessarily prepared to address severability. It wasn't something that we
So
argued.
she's trying to split this up for him
Okay.
any way she can,
If-
get it to fit.
I would hate to.
Can I ask you
concede that-
about, Judge Keenan asked you about infringement.
Here comes another
And
smack.
one of the arguments you seem to suggest here is that this doesn't infringe on, Judge Agee's hypothetical, law-abiding citizen who's threatened and wants to buy a gun to protect himself. He's got to wait 30 days plus, right? Exactly what the number is, doesn't
This is
matter.
gonna be a
30
big
days for
one.
this, 7 days for that, something else for another thing, but 30 days plus. Is your argument that that time period where he cannot buy the firearm to protect his family and his home is not an infringement of his Second Amendment rights, the law-abiding citizen's rights, right? Not the person that you claim you're targeting, but let's posit hypothetically that he's a law-abiding citizen. And he wants to protect his family, and he's got to wait 37 plus days to get it. Is that not an infringement of Second Amendment rights?
Well, first, I just want to push back on the 37 days. The 30-day in the statute is actually is a maximum that can exist.
All right, you want to call it 13 days. Pick a number you want to, right?
Sure, I just wanted to make sure that was understood.
Whatever number you want to pick, right? 13 days. If he had to wait 13 days, is that not an infringement?
It affects Second Amendment rights in the sense that
it denies him his right for 13 days, right? He has no right to possess a firearm for 13 days.
and that's correct, but it's
And is that that's what I'm trying to get at. Is that an infringement of his Second Amendment rights?
No, because what you're saying is a legal conclusion. I don't want to argue semantics, but it affects his rights under the Second Amendment, but does not infringe them.
All right, so let me ask a different question. So imagine you've got a community and you think a crime's about to occur. And so you go to that community and you round up everybody in the community and you put them in prison for 30 days or 13 days, right? And you say, somebody here is bad, right? Most of y'all are great. You're law-abiding citizens, but somebody here is bad and you might be planning to do something bad. Wouldn't we say that's an infringement of their Fourth Amendment rights?
Certainly they would.
Right?
That's
So
a
the
bitch.
law-abiding citizen, just because it's 13 days or 30 days, doesn't mean that it's like de minimis, right? And so you're only in the pokey for 30 days, right? We would say that's an infringement of the Fourth Amendment, right? Even if it was designed to protect the public, right? Because we're concerned about what these two people might do. We don't know which two.
Well, I think that the answer perhaps boils down to the fact that these constitutional rights were enshrined with the understanding that they had at the time of founding. And so when you look at the Fourth Amendment, right, it protects public safety, but it really protects the individual from unreasonable search and seizure. And then you look at the Second Amendment, you look at the distinct history of the Second Amendment, going back to the
And
English Bill
it
of
doesn't
Rights.
protect the individual, is your argument.
It certainly protects the individual, but it doesn't, perhaps not in the absolutist sense.
Well, neither does the Fourth Amendment in the absolutist sense, right? It's not absolute, it's a question of reasonableness, right? It even has reasonableness built into it. But nobody would say that like putting the guy in prison for 30 days or all citizens for 30 days, just so we can try to figure out if there's a bad apple in the bunch, wouldn't be an infringement of the Fourth Amendment.
No, and if reasonableness is the touchstone, then I think
It is in the Fourth Amendment. There's no reasonableness carve out for you in the Second Amendment. The Second Amendment is more absolute than the Fourth.
Thank you, sir. And again, that lawyer gets smacked dead in the face.
Well, I think that to the extent there's a reasonableness in the Second Amendment, it's reflected in the history and tradition. And that's what the state is relying on and going back
So
to.
Because
tell us
spanking.
succinctly, what is the history and tradition you keep referring to?
Preventing dangerous individuals from obtaining deadly firearms.
That's a generic concept. I guess you've admitted you have no founding era statute that's an analog to what Maryland does here.
We were unable to find it, but look at the Bruin footnote 9.
See, and he's fixing to get smacked again, but he just admitted, no, we were unable to find a historical analog. Because it's not there, jackass. He's fixing to get smacked again on that one.
That Bruin in the body of
And I
Bruin.
take it you read footnote 9 as a comprehensive test for all Second Amendment cases, and it's not tied to the public carry context of Bruin case.
I agree, and I look at footnote 9 as just.
Well, that was a question. I wasn't positing one way or the other.
But the state looks at footnote 9 as an extension of just generally applicable constitutional principles that say when you have substantive limitations built into a right, you can have legal mechanisms to enforce them. And that is what Bruin footnote 9 says, is that you can ensure that law-abiding responsible citizens are the only ones who bear arms in the jurisdiction by having upfront background checks, fingerprints, firearms training, mental health evaluations or checks. And Bruen, in its vast historical analysis, yes, it went to the substantive limitations on public carry. But then when it comes to footnote 9, they don't have that same any sort of historical.
Didn't he say at the start of this he wasn't arguing footnote 9? Now he's all arguing footnote 9, trying to get all the stuff crammed into my footnotes, Judge, my footnotes.
Analysis. They say it as if it were just something that we take for granted. And it kind of is, because it's part of the generic constitutional landscape. You can see that in voting cases. We have voter registration. We have photo ID laws that this court has approved of. And what are those but ways of beforehand ensuring that the substantive limitations can be enforced? And so that's the way that this case should be viewed. Is that
Okay, excuse me, Mr. Dietrich. The Supreme Court in Bruen, in the majority opinion, was addressing surety laws that existed at the time of the founding and referenced the fact that they only imposed a de minimis burden on the right to carry.
Now, remember, surety laws is something that came up later, but a surety law basically said if I seemed to be a violent person, I would basically put a deposit down to ensure that I would not be that violent person. If I did something violent, I'd lose that money. It still didn't take my goddamn gun away.
Isn't that correct?
I believe that's correct, Your Honor.
Okay. Why then don't we have to remand this case to the district court to determine exactly what this burden is? I mean, is it a de minimis burden like the surety statutes, or is it something bigger? Apparently, there were restrictions back in colonial times of a different type of restriction on people's right to carry. Why do we want to opine at the appellate level when the district court has never considered this? The district court decided the case under Colby and used the Heller analysis as modified by Colby or as interpreted by Colby. So why do we want to jump in and take this case when the district court hasn't had a chance to see if there are historical analogs? Just because you can't come up with them now doesn't mean there aren't any.
Yes, Judge, there aren't any. That's why they can't find them. See, she's trying to get that shit shoehorned in there, and there's no room for it. It doesn't fit.
And it seems that the law is best served when there's an opportunity for evidence to be taken, the case to be played out under the proper analysis, which wasn't done. The proper analysis was not done because the judge didn't have the benefit of Bruen.
Well, I would agree that if this court is inclined to take that path, then yes, it should be remanded for that consideration.
So what do you do with footnote 6, where it says, the Supreme Court says courts are entitled to decide a case based on the historical records compiled by the parties, right? That the district courts, not under an obligation to go to the Library of Congress and flip through the statute book.
In other words, you have to bring your historical documents with you, and then we decide the case. You have no historical analogs whatsoever, numbnuts. Thanks for playing.
Right? Like, we're not required to do that independent of you, right? We rely on you. And so you've compiled, and this is not a critique of you, right? You've done, I'm certain, the best you can do, but we're entitled to rely based on the record compiled by the parties.
Yes, you can rely on that. That's what footnote 6, that's correct, in Bruen says. But it's always been our position that there is a historical tradition in the substantive limitations that this statute furthers. And with regard to the burden, the administrative burden, the district court already opined on that and said that this was a de minimis burden. And so
right, but the district court did that under an entirely different analysis. It was a pre-Bruin analysis.
I understand. If this court is inclined to remand for
And it was, excuse me, it was an analysis that the Supreme Court expressly rejected in Bruin. They said that we're not going to have this kind of balancing test. And that's exactly what the judge did, because she didn't have the benefit of Bruin. So why would we then try to cobble the law here without giving the district court the first shot at analyzing the case under the existing Supreme Court precedent?
Your Honor, I'm certainly not going to stand in the way if that's what this court needs to decide. And our position is that the district court did decide that, said this was de minimis. With respect to the burden itself on applicants, everybody who is law-abiding, responsible citizen can get an HQL. It's a shall issue regime. And Your Honor, I see my time is up. Are there any other?
So, I mean, I understand why you know, taking the position to affirm, but I guess this is neither here nor there, but I would have kept looking in your brief for an alternative prayer for relief. That if we disagreed or following Judge Keenan's line, that we would remand. I'm just curious why you didn't plead that in the alternative.
Because there was a robust, I mean, Frank, there's a robust record down below that presented evidence on what we believe to be the only issues that was in terms of an evidentiary issue, which was what is the administrative burden on applicants? And that evidence is there. How many people were able to get HQLs? You know, how long it took, what the costs were, and all of those were available for the district court. And again, the state wouldn't stand in the way of this court remanding if this court believed that it needed additional evidence or different evidence to decide the case.
Thank you very much.
Can I ask one follow-up question? I just had one factual question. You seem to rely a number of times on this idea that the HQL was associated with a decrease in homicides in large urban counties in Maryland. You remember this, the sort of argument? But you do that excluding Baltimore City, which is also a county. I know that's confusing. Baltimore City County. But Baltimore City County is like 70% of the murders in those counties, right? So it seems odd to say it's associated with a decrease in these three counties, but 70% of the murders happen in Baltimore City.
Yeah, Judge, thank you very much for that one. And yeah, that was just kind of a double black eye for that douchebag. Yeah, these crimes went down when we did all this stuff. Well, yeah, because you took away, you don't even count 70% of the murders because you completely discount Baltimore. You take Baltimore out of the equation and then say murders went down. Yeah. Smack that ass.
County in Maryland, and that increased when the HQL came out. Can you help me understand how you seem to rely on that as sort of evidence that this works, but when you put the numbers together, it's actually associated with an overall increase in murders.
This is a confirmed kill by this judge
in Maryland, and I'm just trying to understand. You seem to rely on it. It seems to cut the other way. Can you help me understand that?
Sure. That distinction was made basically because of the uptick in crime in general in Baltimore City after the unrest after the death of Freddie Gray in 2015.
Right, but it's remained like in fact the murder rate in 2020 is higher than it was in 2015, right? So that would, excluding Baltimore, would make sense if it popped up and there's this unique instance and then it decreased again. But instead, it's remained at indeed higher levels than in 2015. So excluding Baltimore City from the question of association, which obviously correlation is not causation anyway, but it seems to get the analysis like absolutely backwards.
Well, you're getting into areas where I feel I'm not qualified, but one way may say that the effects.
Yeah, I don't think the expert was qualified either. I mean, that's sort of part of the rub that I've got. I mean, I think he's like just pulling data, right? If you create a correlation by taking out 70% of the data, that doesn't look like actual statistical analysis.
where I was going is I think that the effects of that unrest from 2015 are still ongoing, still very much ongoing. And so you're still seeing the effects even through 2020, which is where the data stops in the record below. But it's just social scientists reflecting factors that they felt were outliers and that skewed the data. And it's there.
Dude, this judge is just beating this cat up, and he is stepping on his tongue every time he opens his mouth.
There for the purpose, both pre-Bruen and post-Bruen, to show that this law has an effect, and so it furthers that substantive limitation, that historical tradition of keeping guns out of the hands of dangerous people, and that it works, because I think that's part of the holistic analysis of that second prong of the Bruen footnote 9 test, which is this an onerous law in terms of, does it diminish or extinguish the right? Is it too onerous? And if it's something works, if something is shown to work, be correlated with something that works, then that is part of the analysis in terms of whether it's too onerous. Thank you.
All right. Thank you very much, Mr. Dietrich. Mr. Dardenne, you have some rebuttal time.
Thank you, Your Honor. Briefly, I would like to just address a few of those points, starting with a point that Judge Keenan made that is absolutely correct. Bruen did away with the balancing test that had been adopted by most of the circuit courts, including this court in Colby en banc. And in doing so, it rejected the idea that the extent of the burden has to be weighed against what government interest is being effectuated and whether or not it is effectual in advancing those interests. And that is precisely what the government is arguing here. Whether or not the burden is de minimis or is extensive or anything along those lines is not a relevant concern under the Bruen test that focuses on the history and tradition and whether or not there is an historical analog to the law that is being considered. Here, the state has already admitted that there is no historical analog for this type of law. Instead, they retreat to the individual component parts, which, as the state has already said, cannot be severed. However, those individual component parts still do not have this historical basis that the government says that they do. For example, the state relies on the idea that individuals would be trained when they showed up for a militia muster. And that is absolutely correct. That was the point of showing up to the militia muster. However,
can you help me for a second? Can you help me? I understand that, severability is maybe not at issue given where we are. But do you contend that if the law just required a fingerprint to buy a gun, which is not this law, I totally get, but it required a fingerprint to buy a gun. So you had to either at the store or bring in a fingerprint card, that would necessarily violate the Second Amendment?
No, I'm not sure. I think it would depend on how that law was structured and what exactly was being done with the fingerprinting. I know here that.
Well, Mr. Nardone, look, I think you need to answer the question though, because what if the law required fingerprinting and to determine whether or not you were prohibited by law from possessing a firearm, such as a prior felony conviction? And what if you were required to just bring that up to the counter to show that you passed the fingerprint check? No waiting period. You passed the fingerprint check. Would that be okay?
I don't think it is, Your Honor.
Why not?
Under the Fourth Amendment, the government cannot compel you without a warrant to provide your fingerprints. The Supreme Court has already held that you cannot condition.
Why are you puffing?
Yep.
Why are you puffing?
So I'm telling you, this judge is trying to get this shit shoehorned in, and it just doesn't work.
The waiver of one constitutional right to be able to exercise another. And for
the Supreme Court, though, seemed to think that fingerprinting could be okay. If you look at footnote 9, it clearly doesn't agree with
go with that footnote again.
That fingerprinting is a compelled seizure of the person. There's no way to reconcile that statement by you with footnote 9. So your answer is that you just cannot. The state cannot require you to present a fingerprint card that's been stamped okay.
I don't think that
Can't
is,
do it.
I think that's correct, Your Honor, and I don't think the court considered whether or not fingerprinting could be okay. In footnote number 9, it listed, among other things, parts of firearm regimes that were not at issue in that court. To the extent it discussed anything, it was discussing whether or not a shall issue regime could still be subject to constitutional challenge.
So wait, just so I understand that, and so Judge Keenan's hypothetical was different from mine. But to go back to my hypothetical, where you just have to be fingerprinted, there's no background check that's happening ex ante. It's not a pre-clearance. You just have to submit fingerprints. Your argument is not that that violates the Second Amendment, but that might well violate the Fourth Amendment.
Your Honor, I would say that it presents the inappropriate choice of which of your fundamental rights you can insist on asserting against the government. Either you can insist on your right to be free from a seizure and present your fingerprints, or you can insist on your right to possess a firearm in the home for self-defense, but you cannot do both. And that, Your Honor,
And you think that's different? You think that's different from like a driver's license, right? That the driver's license would be okay, but the fingerprints are not?
I do, Your Honor, absolutely.
So, Mr. Nardone, you're saying that in your scenario, then a convicted murderer, someone who'd committed several murders but had been released on parole, could not be blocked from obtaining a firearm under any scenario by the state.
Absolutely.
Fingerprinting requirement or anything else. The convicted murderer should be able to get a gun. Murdered his whole family, right? But he can still get a gun?
Absolutely not, Your Honor. As I said, we're not here challenging background checks. Background checks can and have been done without fingerprints for decades. And in fact,
Okay, so how long can a background check take then to not constitute an undue burden on the exercise of the Second Amendment, right?
Your Honor, I think that
Is a
depends.
30-day waiting period for a background check unconstitutional?
Yes.
In your view?
I think it almost certainly is, Your Honor. And also here, I would
Okay, what would meet constitutional standards in your view then for a background check?
First of all, I think background checks in and of themselves are unconstitutional. If you're not committing a crime right then, there's no reason you should have to undergo a background check where the government gets to basically search through your life. That's, the government's not supposed to be able to do shit like that unless you are committing a crime.
In terms of
Well,
time.
I don't think that the time alone can be the manner in which we judge these unless the time becomes so long as it is designed to
Delay.
But why not? Why wouldn't you say, arguably, right? I mean, all these are hypotheticals, right? We don't have them in this case, but why wouldn't you say, listen, so long as it doesn't interfere with your right of self-defense, then that might be the type of a delay that's permissible. And what time would that be? Well, that'd be the time in which you would remain in the store, right? So if you're at the gun store buying a gun and it takes them a half an hour to run your information through a background check, you're in the gun store, your right of self-defense is relatively well protected. We think otherwise. And so that might be enough. But if you have to leave and go home, right, as soon as you have to leave, then your right of self-defense has been infringed.
Well, I think that's the correct lens with which we have to review these things, because just simply saying something is a background check or labeling that way is insufficient. We have to look at the mechanism that's being applied and the effect of it. And so, to Your Honor's point, someone that goes through a NICS check over the phone, the mechanism there is a phone call, and it effectuates a 5 to 10 minute wait. Here, the mechanism is something substantially larger.
Okay, Mr. Nardone.
Far gone over my time. I apologize for that.
Yeah, let me ask you then.
You answer Judge Keenan's
Yeah,
question.
let me ask you then about Justice Kavanaugh's concurring opinion with Justice Roberts, when they both said that fingerprinting is essentially is a legitimate requirement of the state. How does that affect your Bruen analysis? Because they joined the Bruen opinion. They have a concurring opinion, but they're saying that essentially fingerprinting is okay.
Your Honor,
And those were two members of the court.
they were, Your Honor, that's exactly right. It was two members of the court. That opinion did not command a majority, and it is not part of the holding of the court. And in fact, the fact that they would address this separately in a concurrence demonstrates that it is not the way that the majority opinion is being interpreted. Else it would have been in the majority opinion.
Well, it
Yeah.
was in footnote
Well, they-
9, wasn't it?
Damn that
Sorry, Your Honor?
footnote.
It was in footnote 9, wasn't it?
Your Honor, I don't think footnote 9 goes that far. I don't.
Yeah.
But
I need
more
to do a
importantly,
plasma cut that just says
concurrence
footnote 9.
is directed at shall issue carry regimes, which are not at issue here and have different
but my
considerations
footnote-
when the constitutionality is determined, because there is a different historical tradition of possessing a firearm in the home than there is for carrying a firearm outside of it. Your
Amen.
Honors, unless there are any
500.
further questions.
Yeah, one, just so I'm sure factually in Maryland, if I want to go to the gun store in Maryland and purchase a handgun, today I would have to have this handgun permit in hand. I get to the gun store, but to make the purchase, I have to go through an entirely separate process of background checks and all that stuff to actually purchase the firearm.
That's correct, Your Honor. The process starts when you decide you wish to purchase a firearm. At that point, you need to take the time to schedule a course, go get the fingerprinting done. After that's finished, you can submit your handgun qualification license application, which starts the 30-day window. After you receive your handgun qualification license, you then have to go to the store and fill out what's known as a 77R form. Then that is submitted to the state police, and that starts the next 7-day waiting period. And so
So it's 37 days? It's 37 days is total?
37 days from the day that you submit your handgun qualification license application if the statutory strictures are abided by, that's correct. However, you have to start the process before that because you have to obtain the training certificate and the fingerprints before you can submit the application.
So in order to actually purchase the firearm, as I think it is true in basically every state, then that separate process will detect the felons, people that are subject to mental detention orders, domestic violence orders, all those sorts of things. That would be detected at that point before you could actually purchase the firearm.
That's correct, Your Honor. And in fact, that carries another $15 fee.
Anything else?
Thank you.
All
Your
right,
Honor.
thank you very much. We're going to come down and greet counsel, and then we'll move on to our second case.
Yeah, I don't know about you guys, but I think they absolutely slaughtered the state's case on that. I think they beat him like a rented mule. Basically told him, you have no case. None. There's no historical analog for this stuff. But today was a busy day. Because on top of that, you had this.
Has the power to oversee legislative, executive, participate. We're going to have.
So this was a hearing that happened today, started this morning, on reining in the agencies and all their little regulatory schemes. Let's try to speed this up where they kicked in.
We're going to have to take a break for votes at some point in this hearing. We welcome everyone to the first hearing of the Subcommittee on the Administrative State Regulatory Reform and Antitrust. The chair now recognizes himself for an opening statement. In some ways, the importance of today's hearing goes back to the founding era. Even before America declared its independence, John Adams emphasized that a republic is a government of laws, not of men. This hearing is about who makes the laws in our country. It's also about how Congress should reclaim its legislative power from the administration.
Now, they talk about the ATF some in this hearing, in a couple of cases. They mentioned the pistol brace rule. They mentioned, I think, frames and receivers, To me, they just didn't mention it enough. But they are talking about Chevron deference and stuff in this hearing too.
State.
What's up, Chamber?
This is an important discussion. By way of background, the U.S. Constitution separates the powers of government between the states and the federal government. It further separates the powers among the three branches of the federal government. Importantly, Article 1 of the U.S. Constitution vests the federal legislative power in Congress. In other words, the words of Chief Justice John Marshall, powers are separated with the intent that the legislature makes the law. But in the modern day, we have seen a troubling consolidation of powers in the executive branch. That is, in part, because of how many regulations, binding rules that affect the American people are coming from the executive branch. Indeed, in recent years, the administrative state has issued regulations carrying the force of law more than 20 times as frequently as America's elected representatives have passed laws through the process the Constitution requires. When Chairman Jordan invited me to chair this subcommittee, I asked him what the topics were, what would be our jurisdiction. And he said that administrative law would be our jurisdiction. And I said, well, you've just given us jurisdiction over about 95% of the federal government. And I'd be
hell yeah, Chamber.
Happy to chair that committee. What this means that so much of the law is administrative law, unelected bureaucrats and the branch tasked with executing the laws are instead making many of those laws that bind the American people. The modern administrative state's violation of these fundamental principles is significant. In our country, lawmakers should be politically accountable to the electorate. As Professor Philip Hamburger wrote in his book, The Administrative Threat, quote, "These are core civil liberty issues. Binding agency rules deny Americans their right under Article 1 to be subject to only federal legislation as enacted by an elected Congress, and such rules thereby dilute the constitutional right to vote. But today, Americans must routinely follow rules that come from a source other than Congress. In recent years, federal agencies have more and more frequently imposed their will on the American people. To name just a few examples, OSHA's vaccine mandate, the national eviction moratorium, the FTC's proposed non-compete rule, and ATF's recent rule on stabilizing pistol braces, not to mention waters of the United States, which incidentally is like a ping pong match. Every time we get another administration, whether we went from the Bush administration to the Obama administration, we got a new waters of the U.S. law, a new interpretation of the Clean Water Act. And then when we went from Obama to Trump, we got a new interpretation of the Clean Water Act. And now we've gone again to Biden's rules. Each of these examples shows the administrative state, not Congress, attempting to or actually imposing binding
Yeah, Chamber, I actually dropped mine apart last night.
rules on the American people. Consider the ATF's pistol brace rule. It requires gun owners who use stabilizing braces, not bump stocks, Mr. Ranking Member.
Yeah, the dude sitting next to him, Cicelyne, is the one that said pistol braces turned guns into machine guns and worked like bump stocks.
To register their braced pistols, modify their weapons, or risk potential
And Massey's just busting his balls right there.
felony charges. In the words of James Madison, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. That quotation by James Madison implicates an administrative state that makes law. Today's hearing is about exploring the need
Damn, brother, was that bad?
for Congress to reclaim its legislative authority and to discuss potential legislative responses. Some legislation, like the REINS Act and the Separation of Powers Restoration Act, are steps in the right direction. Ultimately, Congress needs to reestablish itself, not government agencies, as the main driver of federal policy. I'll end with this final point. Although some conflate this hearing's focus with deregulatory efforts, that need not be the case. We're not arguing that there don't need to be any regulations. Put simply, we can and should have a discussion today about where law should come from. And as set forth by our Constitution, binding rules should come from politically accountable elected representatives, not from the administrative state. Reasonable minds may differ about certain policies, but we in this body should all be on the same page about who should be making our laws, and that is Congress. Before I recognize the ranking member, I want to thank him for his service in Congress and tell him that we're going to miss him. I hear that he's leaving this session early, and I hope it's not because I am the chairman of this committee. And now I recognize the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman.
Yeah, this is the dude who thought pistol braces turned guns into machine guns. He is an absolute moron.
And I congratulate you on chairing this committee and for our first hearing, and can assure you that your ascending to this chairmanship did not contribute to my decision to leave early. Mr. Chairman, it's just over a month now that the Suffolk Southern train derailed in East Palestine, Ohio. setting off
Damn,
a
brother.
cascade of events that have put countless lives at risk. Crews are still cleaning up the highly
Yeah,
toxic
that is
chemicals
chewed
that were
up.
released into the water, ground, and air. We will not know the full effects of this environmental and safety disaster for decades. This subcommittee is charged with overseeing regulatory reform, which is clearly much needed. And yet today, instead of using our first hearing to discuss what and how we must ensure that the government is acting to not only help those in need right now, but also to implement new safety and environmental regulations that would prevent a disaster like this from ever happening again, we're talking about, and I quote, reclaiming Congress's legislative power. I frankly didn't know that this is a power that had been lost. And at the center of today's hearing is, of course, the regulations from the Executive in Need of Scrutiny Act of 2023, or the REINS Act, which would not, in fact, make rulemaking more efficient or responsive to public concerns, but instead would hinder the most basic functions of our government to keep people.
Yes, we want to hinder your most basic functions, because when you're hindered, you're not stripping someone of their natural rights.
Safe. By requiring that both the House and Senate pass and the President sign a joint resolution of approval before any major rule issued by an agency
that
can
is
take
weird.
effect, we are effectively negating the authority we have already given these agencies. Let me make it plain. Congress already has the power to oversee agency rulemaking, and agencies can only exercise authority that we grant them. What the REINS Act would do, in short, is prevent agencies from keeping dangerous products off the shelves and toxic chemicals from polluting our land, air, and water.
He's so full
There's
of
nothing
shit.
more than, this is nothing more than a congressional power grab that will lead to even more deregulation that puts people at risk and will pave the way for reckless and powerful corporations to put their profits ahead of the health and well-being of the American people. The REINS Act would prevent the Consumer Product Safety Commission from updating safety standards for infant walkers like they did in late 2022.
No, it won't. It won't stop them from doing stuff like that. If it's an unsafe product, they can still manage it. You know, if someone's dumping toxic shit into the water, EPA can still manage it. What this says is they just can't go make up their own damn rules.
Responding to alarming news that these products have become a leading cause of death and injury for small children. The REINS Act would prevent rules from the Food and Drug Administration, like their August 2020 rule to more quickly identify and remove potentially contaminated food from the market, resulting in fewer deaths and illnesses. And finally, rules like the FDA's hearing aid regulation that will lower costs for millions of Americans and allow people to get hearing aids over the counter would be blocked under the REINS Act.
No, it wouldn't, you jackass. The only reason you can't get hearing aids over the counter right now is because of government regulation. How are you going to say stripping the government of that regulation is going to stop it if the regulation's actually stopping it? Is it just...
Deregulation led to last night's derailment in East Palestine and Norfolk Southern's recent derailment in Springfield, Ohio. Further deregulation will lead to even more tragedies in the future. For years, at the behest of companies and special engineers.
Now notice, they haven't even really nailed down a cause for the train derailment yet. It could have been anything at this point, but he's blaming it on deregulation.
The Federal Railroad Administration has engaged in deregulatory efforts despite workers' calls for necessary, stronger safety measures. We cannot place companies' greed over public and worker safety and the cleanliness of our air, water, and land. Railroad workers have a saying their safety regulations are written in blood, because it is only after disasters up to including the loss of life if pro-safety changes are made. This is absolutely unacceptable. Agencies are charged by the authority of Congress grants to enforce our laws. They do that in part by issuing those rules. And to that end, I hope my colleagues on both sides of the aisle will join me in supporting legislation that would make industry and our government more accountable by ensuring that all agencies.
Oh, man, make no mistake. He is a moron, but he's reading stuff that other people wrote for him to protect that government power. And one of the witnesses in here, you guys will see her. She's a complete little mini-ass tyrant.
Issued rules are based on rigorous studies and free from bias like the Stop Corporate Capture Act introduced by Representative Jayapal. At a time when residents across 3 states are grappling with the highly toxic fallout of a culture of deregulation and lax safety standards of the Trump administration, we need to be focusing on how to make rulemaking more effective and efficient, not gunking up the wheels. And I thank you, Mr. Chairman, and with that, I yield back.
Thank you, Mr. Cicilline. I now recognize the ranking member of the full committee for his opening statement, if he has one.
Thank you, Mr. Chairman. Mr. Chairman, at a time when the nation is reeling from multiple train derailments in Ohio alone, as well as increasingly harsh storms due to climate change, and an outbreak of...
Yeah, here we go, a Humpty fucking Dumpty. If his belt gets any higher when he tightens it, he's going to choke himself out.
Avian flu that has led to the deaths of tens of millions of chickens in our food supply, and experts tell us could conceivably jump into other species, including humans, and could conceivably cause another pandemic. I find it telling that we're using the first meeting of this subcommittee.
Since he said that, should we like mark this day? Because there were things said in hearings before, like COVID hit, where people said that something may happen, and then poof, COVID hit. So he's talking about avian flu, bird flu hitting people. Should we mark this day so in the next year or two, when the bird flu does hit us, we know what was coming? Maybe a little gain of function research was happening.
Committee, not to discuss how we can better serve the needs of all Americans, but rather how we can remove public health and safety safeguards for the sake of higher company profits. And how do Republicans plan to advance their extreme agenda of protecting profits over people? By trotting out the same old, tired anti-health and safety legislation that they have tried year after year whenever they control the House. We are only 3 months into the new majority, and I guess they are already out of fresh ideas. One of the bills we are examining today, the regulations from the Executive in Need of Scrutiny Act of 2023, or the REINS Act, has been considered in every Congress in which Republicans have held the majority since 2012. The REINS Act is grinding the gears of rulemaking to a halt by requiring all major rules to be affirmatively approved by both chambers of Commerce.
This is where I wish I was real good at editing video, because as soon as he came on, I'd play the clip of him shitting himself and trying to sidewalk off the stage.
A regulation would be blocked from being implemented if even one House declines to pass an approval resolution. The goal of this legislation, quite simply, is to stop the regulatory process in its tracks, regardless of its impact on public health and safety. The bill purports to give Congress control of the rulemaking process, but Congress already has this power and exercises it in a number of ways. First, Congress can delegate authority to agencies with specificity, thus limiting the scope of the agency's authority. Second, it can impose restrictions on rulemaking through appropriations. Third, it can influence rulemaking through oversight activities. And if all these measures are insufficient, we also have the blunt tool of the Congressional Review Act, which allows Congress not only to overturn a rule, but also to bar the agency from ever passing a substantially similar.
Yeah, and this is why I think Dettelbach has actually got this hearing is kind of a pre-hearing. So I believe in the next couple of weeks or so, Dettelbach's supposed to be in front of Congress. Now, he has ignored requests for any kind of information for the last, year or so. Anytime someone asks him for information, they just blow it off. So I think he's going to end up getting subpoenaed to come in front of Congress.
rule. The REINS Act is not only redundant, but it also creates insurmountable procedural hurdles that would stall the approval of rules of major impact, rules that would be highly beneficial to the public's health and safety. It's important to remember why we have regulations in the first place. Congress sets broad policies, but we delegate authority to executive agencies because we do not have the expertise to craft technical regulations ourselves. Who here knows how many parts per billion of arsenic should be allowed in our drinking water?
That is why you bring experts in front of you and you question experts, and then you make the law. You don't make the law and then throw it to an agency that doesn't have any power and tell them to work it out. These people are statist morons.
Is 10 the proper amount? Should it be 5 or 15? None of us here knows the answer. But the dedicated professionals at our federal agencies, many of whom have decades of experience and vast technical expertise, undertake a careful process to protect our health and safety. This process includes numerous procedural safeguards, including public notice and comment. Regulations ensure that our air is safe to breathe, our water is safe to drink, our food is safe to eat, and the life-saving medications we depend on are safe and effective. It means that the cars we drive and the planes we fly have proper safety mechanisms, and that banks and credit card companies cannot take advantage of unsophisticated borrowers. And when we do not properly regulate, sometimes it means that trains carrying dangerous chemicals can derail in our communities, putting thousands of people at risk. I feel much better about leaving regulatory decisions to the careful study of agency experts rather than to members of Congress who want to substitute their judgment subject to the whims of politics. Republicans also want to eliminate the Chevron doctrine, which calls for courts to give deference to an agency's reasonable interpretation of its statutory authority. So if it's not members of Congress regulating our health and safety, I guess it will be federal judges. Republicans have spent decades waging an all.
And remember, Chevron deference should never be used in a criminal matter. Chevron was only a regulatory matter. It shouldn't have been there in the first place, but it was only supposed to be used as a regulatory matter, not as a criminal decider.
All-out assault on the regulatory process, trying to add hurdle after hurdle on the ability of agencies to issue regulations that protect public health and safety. Regulations whose benefits consistently outweigh their costs, often by many multiples. If we want to improve the regulatory process, we would consider legislation such as the Stop Corporate Capture Act, which would bring more transparency and accountability to the rulemaking process. But instead, the subcommittee has chosen to make their first order of business the dismantling and destruction of the regulatory process, regardless of the impact on public safety, public health and safety. This gives us a good idea of the priorities we should expect to see.
Waffles, Chevron deference. So it came out in a case, I think it was the EPA against Chevron Oil Company. But Chevron allowed the EPA to basically interpret a rule or a law like they wanted to. It didn't have to be spelled out, clear cut. So in other words, they could argue over whether a zebra is a zebra, and the government could just say, no, but it's a platypus. We think it's a platypus. Therefore, we're going to charge you with being in possession of a platypus when you have a zebra. It gave the regulatory agency all the interpretive power.
See out of this new extreme majority. I hope they will reconsider this dangerous agenda, and I yield back the balance of my time.
Thank you, Ranking Member Nadler. Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. Allison Ho is a partner and a co-chair of the Appellate and Constitutional Law Practice Group at Gibson, Dunn, and Crutcher. She has argued cases before the Supreme Court, state Supreme Courts, and various state and federal appellate courts. She previously served as Special Assistant to President George W. Bush, Counselor to Attorney General John Ashcroft, and she clerked for Justice Sandra Day O'Connor. Jonathan Wolfson is the Chief Legal Officer and Policy Director at the Cicero Institute. His research at Cicero focuses on healthcare regulatory reform and employment policies. He previously led the policy office at the U.S. Department of Labor. Ryan Kleckner is the co-founder of Gun University, LLC, and a former Army Ranger. He is an attorney and previously served as Vice President of Compliance at the Remington Outdoor Company and as a Manager of Government Relations at the National Shooting Sports Foundation. Emily Hammond is the Vice Provost for Faculty Affairs and the Glenn Earl Weston Research Professor at the George Washington University Law School. Professor Hammond's research focuses on energy law, environmental law, and administrative law. We welcome our witnesses and thank them for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? The record will reflect that the witnesses have answered in the affirmative. Thank you, and please be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. The microphone in front of you has a clock and a series of lights. When the light turns yellow, try to begin to conclude your remarks. When the light turns red, your time has expired. Ms. Ho, you have the distinguished honor of going first.
Thank you, Chairman Massey, Ranking Member Cicilline. Thank you for inviting me here today to testify about reining in the administrative state. I'm heartened to see this issue being debated in Congress. Our system of checks and balances can only work when Congress is active in its engagement with the other branches, including the executive branch. And that's particularly important when we're talking about the modern administrative state, where the executive branch regularly runs the risk of encroaching on the authority of the legislative branch. So regardless of what actions this Congress chooses to take in response to the rise of the administrative state, I think this hearing alone serves an important function in Congress fulfilling its responsibilities under the Constitution. In my remarks today, I want to discuss one specific issue that has coincided with and likely accelerated the rise of the administrative state, doctrines that force courts to defer to administrative agencies. The most well-known of these doctrines is Chevron deference, which originates from a 1984 Supreme Court decision, Chevron USA versus National
Mike, what's up?
Defense Council. And that case holds that when a court is reviewing an agency's interpretation of a statute that it administers, the court should defer to the agency's interpretation if the statute is ambiguous and the agency's interpretation is reasonable. There are other types of judicial deference as well. For example, our deference holds that courts should give controlling weight to an agency's interpretation of its own regulation, unless the interpretation is plainly erroneous or inconsistent with the regulation. There are several significant flaws with judicial deference to agency interpretations, and I'd like to highlight just a few of them. First, it flies in the face of the bedrock principle underlying the rule of law. A law means what it says. A statute or a regulation has a correct interpretation, and it is that correct interpretation which should govern our actions. Deference to an agency's interpretation turns that fundamental principle on its head. Courts no longer care whether the agency has the correct interpretation, just whether the interpretation is reasonable. And suddenly this reasonable interpretation, which may or may not be correct, becomes the law. To enforce an agency's interpretation of the law, even though it is not the best interpretation, is inconsistent with the judicial branch's constitutional duty to say what the law is, contrary to Congress's directive in the Administrative Procedure Act, and harmful to confidence in our legal system. Second, deference doctrines have become a tool for agencies to expand their power and influence, often at the expense of individual rights and freedoms. One of the biggest problems with deference is that it allows agencies to effectively write their own laws. Because courts are
She could say that 10 times and it would still be just as beautiful. Because she's right. You're allowing agencies to make up their own rules. It's like a fox in the hen house, and the fox makes up the rules. Well, I get to eat 2 chickens today. And then you tell the fox he can't eat chickens no more. And he says, no, really, I can eat 2 tomorrow too.
required to defer to an agency's interpretation of a statute if it's reasonable. Agencies have an incredible amount of discretion to interpret laws in a way that gives them more power and authority. This can result in regulations that are far more burdensome and restrictive than anything Congress intended when it passed the underlying law. And third, these deference doctrines undermine very fundamentally the separation of powers that is so critical to our system of government. When agencies are given broad authority to essentially write the laws, write regulations that have the force of law, they are stepping into the role that Congress has, not the executive. Moreover, even though agencies are technically within the executive branch, the rise of the civil service and the vast expansion of the federal bureaucracy has effectively made them a 4th branch of government with the power to make laws and enforce them with little effective political oversight. Elected officials are supposed to be held accountable to the people who elected them, but the administrative state is often staffed by unelected bureaucrats who are difficult to hold accountable, even by the executive. This can make it hard for the public to have a say in the laws and the regulations that affect their lives. The more you believe in democracy, the more you should be concerned about the rise of the administrative state. So what can be done? There are many solutions, but part of the growth of the administrative state comes from congressional neglect. When Congress passes laws that are open-ended, when Congress doesn't react to civil agencies that are acting outside the bounds of their authority, all of that empowers agencies to continue expanding their influence. So to end where I began, I'm grateful for the committee's invitation to testify today. I hope I can answer any questions you have and help in any way I can in your efforts to rein in the administrative state. Thank you.
Thank you, Ms. Ho. Mr. Wolfson, you may begin.
Chairman Massey, Ranking Member Cicilline, and members of the subcommittee, good morning and thank you for having me today. It's an honor to testify on Congress's role in creating law and oversight when executive branch agencies start to write laws instead of simply working to enforce the law that's already written. My name is Jonathan Wolfson, and I'm the Chief Legal Officer and Policy Director at the Cicero Institute, which is a nonprofit think tank focused on identifying, developing, and advancing entrepreneurial solutions to society's toughest public policy problems. Previously, I had the honor of serving as the head of the Office of the Assistant Secretary for Policy at the U.S. Department of Labor, as well as the Regulatory Reform Officer at that department. Today's hearing centers on ways that Congress can bring additional accountability to federal rulemaking, whether by limiting the power of the executive branch to act absent congressional authorization or requiring legislative approval of regulations. Today, I will focus on 4 key points. First, the legislature should create laws, and the executive branch should encourage compliance and enforce those laws. Secondly, the legislative branch is more accountable than the administrative state. Third, agencies have expertise in the regulatory process, not necessarily on making legislative decisions. And fourth, the REINS Act appears to be a valuable step toward restoring Congress's and agencies' appropriate roles. Before we dive in further, I'd like to clarify that while colloquially, regulation often means government restrictions, regulations are actually agency rules that purport to effectuate statutes. This is important because too often discussions of deregulation devolve into caricatures where proponents of deregulation are asked to defend whether they care about clean air, safe food, or fair banking practices. Congress can pass laws to protect air, food, or finances through statute without subsequent agency-driven lawmaking.
Thank you, sir.
So let's talk about why agencies are not supposed to make new laws. Basic Schoolhouse Rock civics lessons teach us that Congress makes laws and the president executes and enforces those laws. But members of this subcommittee know that that isn't really the reality. Unfortunately, the executive branch and independent federal agencies regularly make new laws and fill intentional or unintentional gaps left by Congress. And at times, regulatory agencies even act to make new laws without any congressional authority at all. Now, Congress does bear some responsibility for this phenomenon. New laws are often vague. Sometimes this is out of neglect, sometimes it's out of convenience for the legislature, and sometimes it's out of apparent necessity. But often this leaves vague and big questions for the regulated community. But regardless of the cause, I would argue that this is not the ideal that we should be aiming toward. And as Ms. Ho just mentioned, this is not the ideal that the Constitution sets up for us. Secondly, Congress is accountable and agencies are not. Another key reason that agencies ought not legislate is that voters may hold legislators accountable for their action. Accountability is especially important where there are trade-offs between different constituents and competing interests. When a secretary supports a particular policy, the agency's staff do as well, that policy is likely to prevail. And traditional deference principles mean reasonable regulations stand, even in the face of strong objection. Given the substantial burden and the limited ability of Congress to hold the agencies accountable, Congress ought to write the laws. Third, unique agency expertise often lies in regulatory process. Some proponents of the administrative state contend that Congress lacks expertise on a range of issues that face our nations, and agencies have the depth of knowledge and experience necessary to write the laws. They argue that Congress could codify public sentiment and leave the regulatory details to the agency experts. While regulators do bring specialized knowledge and years of experience in government to the table, it does not follow that this experience makes them better at making the rules than a member of Congress would be if given the opportunity. Even assuming that the typical federal official writing regulations is a neutral, unbiased subject matter expert who leaves his or her own preference.
So this, I'm gonna cut them off for a second, but this is where if an agency needs to regulate something, they should have to come to Congress, sit down with Congress, sit down in front of them and say, hey, this is the law we need you guys to make so that we can regulate, part B over here. And then Congress should have to pass it, get agreement, pass it, president signs it, and they can send it on. We all know this can happen in a very short amount of time because we've seen Congress move bills that they really wanted within days, get them to the president's desk.
Aside, do they possess the right kind of expertise? Unfortunately, many agency staff have narrow expertise, often in creating and enforcing regulations, rather than on important trade-offs that occur in the real world. And even when they have field-level expertise, their relative comparative advantage compared to academic or industry is knowledge and experience in how the government works, how to get something published in the Federal Register. So they revert to regulation, even if regulation is not the best path forward, because regulators regulate. This knowledge of the rules also helps them impose new regulations via guidance, which doesn't have to go through all the Administrative Procedure Act hurdles. To limit this overreach, I was honored to sign the Department of Labor's regulatory openness through good guidance rulemaking. Fourth, Congress can use the REINS Act to rein in regulatory excess. The REINS Act is a good proposal to restrict legislative activity by agencies and restore the proper relationship between the legislative and executive branches. The REINS Act is the next in a series of laws to limit regulatory autonomy and require particular regulatory processes to ensure the constitutionally required balance of power. Thank you again for the opportunity to testify and share my perspective. I look forward to answering any questions you all may have.
Thank you, Mr. Wolfson. Mr. Kleckner, you may go now.
Good morning, Chairman Massey, Ranking Member Cicilline, and members of the subcommittee. I am Ryan Kleckner. I'm a former Special Operations Sniper, and I'm a firearms attorney that specializes in federal firearms law and ATF compliance, among many other projects in the firearms industry. I am concerned with federal administrative agency overreach with respect to rulemaking. I believe that power in the government should be limited and it should only be in the hands of those accountable to the people. And decisions and debates on matters in legislation should be open and transparent to the public. Allowing non-elected and non-representative government bureaucrats and federal agencies to exercise power that should be limited to Congress and to do so behind closed doors without accountability nor transparency is destructive to America, its citizens, and Congress. I implore you to not let these federal agencies under the executive branch continue to steal power that has been entrusted to you by us. A recent example of agency overreach where laws are being changed by unelected bureaucrats with decisions being made behind these closed doors is ATF's latest rule 2021R-08F. It's factoring criteria for firearms with attached stabilizing braces. It was published in the Federal Register on January 31st of this year. This latest rule that the ATF has made, it redefines laws that have been passed by Congress, and it criminalizes the possession of firearms with certain accessories that the ATF itself had previously specifically approved. This rule by fiat effectively gives the ATF the power to determine who is a felon by the stroke of a bureaucrat's pen.
Yes, sir.
This is not an appropriate enforcement of law. It is tyranny. It's unfair for the ATF to expect the average citizen to not only be aware of these changes, especially since the ATF itself has waffled back and forth over the years on pistol braces alone, but expects citizens to make these determinations about these objects themselves without clear direction about what the ATF considers to be legal. However, even with clear instructions, these changes to legal definitions within the law are not appropriate for the ATF to make. If Congress doesn't rein in federal agencies, and these agencies are permitted to continue to change laws and provide this conflicting guidance to citizens, I believe that chaos ensues. Thank you for the opportunity to speak here today, and I'm willing to answer any questions you may have.
Yeah.
Thank you,
Here
Mr.
we
Kleckner.
go.
Professor Hammond, you may begin.
Thank you, Chairman Massey,
Tell me if she fits the part.
Ranking Member Cicilline, and distinguished members of the subcommittee for the opportunity to testify today. I'm a professor of law at the George Washington University Law School, where I do indeed specialize in administrative, energy, and environmental.
What's the over-under on how many cats this lady has?
Hey,
I know I married the crazy cat lady, but this one takes the cake.
Law. I have previously served
I
in
had 9
federal
cats at one
agencies,
point,
both
right?
as legal counsel and in my previous career as an engineer, where I co-authored several scientific publications. I'm deeply concerned about the REINS Act. It's impractical. It's harmful to the people of this country. It eviscerates 2 cores of government legitimacy: participation and reasonableness, and it is likely unconstitutional. Congress has long recognized that among the branches of government, agencies within the executive branch are best positioned to leverage specialized expertise to tackle the most challenging issues that we face as a society. Whether protecting the functioning of our markets, keeping workers safe, or protecting the air we breathe, these challenges are incredibly complex and difficult to address solely in the legislative arena. So, in its wisdom, Congress establishes the statutory basis for action, but tasks the executive branch with the duty to bring that legislative vision to life.
Disturbing.
And Congress has put a number of guardrails in place. For rulemaking, these include the participation, deliberation, and reason-giving requirements that stem from the Administrative Procedure Act. Notably, these features of rulemaking are fundamental
That
to
seriously
democratic
looks like one of the
decision-making.
stock
They
haircuts
guard
you
against
could give one of your
arbitrariness,
Fallout
and they
characters
promote
when
oversight
you're
through
building your
transparency.
character.
In particular, that reason-giving requirement ensures that Congress and the public can both understand the basis for the decision and see whether the agency has maintained fidelity to statute. Now, there is always room for improvement in agency decision-making, and Representative Jayapal's Stop Corporate Capture Act, for example, offers several upgrades. These are aimed at empowering the public, ending corporate manipulation, attending to social equity, and minimizing the dysfunction that OIRA review can engender. By contrast, the REINS Act would replace scientific-informed, participatory government decision-making with an utterly impractical system. Congress is neither designed nor staffed to deeply evaluate every single agency's major rules, especially within such short time
It does,
frames.
man. It looks.
And the
I
suggestion
swear to
that the
God,
REINS
I've seen
Act
that
is meant to
haircut when I
promote
was designing
legislative
my character on
transparency is
Fallout to
baffling.
look like one of the.
It permits only 1 or 2 hours of
not the
debate on the joint
Outlanders.
resolutions, and otherwise
One of
sets
the gang
such
members.
tight timeframes that it is difficult to understand how legislators could give careful review to each
Yeah, it
regulation.
probably does, Mike.
This scenario promotes opacity and heightens the risk that votes will be based on naked political preferences that would not be permissible in the agencies themselves. Right now, America needs more.
All these people do is make political decisions.
Protections, not fewer. We know from the East Palestine disaster what an anti-regulatory culture can do, and we have seen these lessons across our history. We know as well that weak regulatory protections mean fewer people make it home to their families after work. More people die too soon, and we hasten and intensify climate disasters. This is not idle speculation. It's backed up by the cost-benefit analyses that the REINS Act asks for, but that are already available for review by Congress and the public.
Oh, damn, Mike, that's cold.
Finally, the REINS Act is concerning
like she
because
should
it
be
blurs
Jeffrey Dahmer's
separation
sister.
of powers beyond what the Constitution can bear.
I'm pretty sure
On
she
one
eats
hand,
human, though.
if the joint resolution process is a legislative act, it must meet constitutional requirements for doing so. On the alternative, it would violate separation of powers for Congress to exercise the executive function of finalizing regulations. To conclude, the unconstitutional REINS Act would fail to achieve what it promises and would instead harm.
How is it unconstitutional to take power away from an unconstitutional agency? Seems to me that's pretty damn constitutional when you have the legislatures taking the power back from the alphabet, considering the alphabet shouldn't even exist and they are unconstitutional. The state is cat lady right here thinks the government should have control of every bit of your life.
Our economy, our safety, our health, and our environment. Thank you again for the opportunity to testify today, and I look forward to your questions.
Thank you, Professor Hammond. We'll now proceed under the 5-minute rule with questions. And I recognize the gentleman from California, the chairman of the IP subcommittee, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. You know, it's always interesting to be told something is unconstitutional in this body by a professor who just doesn't like how Congress might rule. So I'm going to start with Mr. Kleckner, since you fought to defend our.
He just smacked the shit out of her right out the gate. It's always, nice to have someone call something unconstitutional just because they don't like the way we're doing shit.
Country and her right to be wrong.
Damn.
Let me ask you a question. Do you think for a moment that a body that regulates one way and then regulates another way is consistently meeting the congressional mandate that they interpret but not make laws?
Of course, it would depend on the situation, but the way it's happening now, no.
Right. In your case, they fully executed, knowing what the devices did, regulations and categories, and now they're changing them based on a political, oh, these are too dangerous, these are this, these are that. Whatever their reason is, they're making a political decision to make a change that is not supported by a change in the hardware or the change in the statute. Is that correct?
I believe so. I do not think this is a regulation that is promulgating current law. They are specifically in the ruling calling out what the current law is and then saying we are redefining that to be this instead. They're actually changing the language of the law and the definitions.
Mr. Wolfson, you looked a little uneasy as the last witness spoke. The unconstitutionalist claim.
Dude, he is just going flat out Viking on her.
That we just heard. Is it correct, and I'll ask both the other witnesses, is it correct that we could strip every single statute by a rule, by simply the House and the Senate voting to do so, and eliminate all statutes since the beginning of time and start over if we chose to, and that would be constitutional?
My understanding of the Constitution is that, yes, if Congress passed a law to strip all current statutes, that they would be allowed to do that.
So unless it is within the 27 amendments and the original Constitution, which we cannot strip by congressional fiat, everything else by a 2/3 majority over the objection of a president can be eliminated to zero. Is that correct?
That's my understanding.
Okay, so any failure in the REINS Act to meet some sort of a constitutional test as written would simply be that we probably didn't write the REINS Act quite specific enough to assert the powers that Congress clearly has. Is that correct?
I would assume that that would be the argument, would be that the language of the REINS Act as currently drafted may have some sort
Dude,
of
I can just see the
constitutional defect, but
glasses flying in like
of the
it does on some
legislature
of the
being
skits
able
and
to
landing
say,
on his face
we're going to
with
create
big
a
old
rule that
giant hair.
says all the regulations have to come back to Congress, considering Congress theoretically gave the agency the authorization to write them.
Right. And so now in the case of the Federal Trade Commission, which you
Oh,
opined
yeah,
on,
dude. ICE just
clearly
roasted
they
the
are
shit
now
out of her.
asserting areas that they never asserted for their first decades of existence. Is that correct?
That's correct. There are certain regulations that are being proposed by the Federal Trade Commission, specifically the non-compete clause regulation, which it does not appear that the FTC was ever given authority to do that sort of regulation, regardless of whether that is good or bad policy.
Right. So, Ms. Ho, I don't want to leave you out of this. The Chevron deference that ultimately creates the ability for, if you challenge in court, the assumption that somehow the Congress has simply had ambiguity. Do you see in the ATF or in the FTC, do you see ambiguity in the original law that would cause decades after one precedent was set to be changed simply by a change in who happens to occupy the chairmanship and, of course, the White House?
Thank you for that question. I wouldn't presume to comment on the details of any specific legislation, but I would go back.
Well, Chevron isn't legislation. Chevron is a Supreme Court decision that essentially says the court is going to assume that these agencies act in good faith and that it's simply ambiguity in the law. Do you believe there's ambiguity in either of these two decisions, or are you unwilling to comment on them?
Oh, I can't, I'm not in a position to comment on either of them, but I do underscore the significant flaw in the Chevron approach, which essentially takes away this body's ability to make law and also the judiciary's constitutional responsibility to say what that law is.
So in my remaining few seconds, for all of the witnesses, including Ms. Hammond, is it fair to say that instead of working on the REINS Act, perhaps we should be working on explicitly eliminating Chevron and putting the deference back to you must return to Congress if there's ambiguity? Any comments?
The gentleman's time has expired, but I'll allow one witness to respond to that. Mr. Wolfson.
I guess I'll take it. I think that eliminating Chevron deference or curtailing it significantly would be an action that Congress could take, which would have an even bigger effect than something like the REINS Act, because the REINS Act was only prospective, whereas eliminating Chevron deference affects all regulation that are currently on the books.
Thank you, Mr. Chairman. I yield back.
The gentleman yields back. The chair now recognizes the gentleman from Rhode Island, ranking member, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman.
Yeah, here we go with old pistol braces turn guns into machine guns, and everybody's gonna die.
I'm going to quickly dispense with one thing, Mr. Wolfson. You said in your testimony here just now and in your written testimony that agency expertise is really expertise in the regulatory process, not on the complicated trade-offs between competing priorities. You're not suggesting, I hope, that the thousands of scientists who work at the FDA or the thousands of engineers and products experts that work at the Consumer Product Safety Division are only experts in the regulatory process and not the underlying science or engineering that they were trained to do, are you?
I would say that.
Thank you for the question. No, I'm not suggesting that they.
Thank you. So my point is, regulators have expertise, not just an understanding of the regulatory process, but they're hired in these agencies of the federal government because they bring with them life-saving training and science and expertise that we don't have as members of Congress. And so the notion of
now remember, one of his experts is really the one that told him bump stock or pistol braces make guns into machine guns. He didn't come up with that on his own. Someone told him about it, and he agreed to it.
Like all they know about is the regulatory process, which is what you say here. That's exaggerated. It's actually the underlying substance of their expertise that is saving the lives of the American people. So I just wanted to be sure that you weren't making a claim to the contrary. Professor Hammond, what I want to ask you about is, would the response to environmental calamities like the one that was caused by Norfolk Southern train derailment, East Palestine, be better or worse off if the EPA were subjected to the RAINS Act that is being offered by my colleagues on the other side of the aisle?
Thank you for that question. Very much worse off. Agencies need those regulations to then carry out their work, whether that's investigatory work or enforcement work. Plus, one of the things I want to emphasize is that regulations protect people in the first place. They help keep disasters like East Palestine from happening.
No, they don't. See, you guys wanted to regulate trains so heavy that instead of being able to transport these things by rail, we would have had to put them on trucks and put it on the road where there would have been more accidents. Cat lady.
So we can back it up a minute and just think about, let's prevent harms instead of waiting for disasters.
And, would requiring Congress rather than agencies that are equipped with both expertise and professionals who do this work, a body of, Congress, those of us that are elected members who are not scientists or experts on public health or environmental protection, worker protection, safety provisions,
guns.
Would it endanger the lives of the American people if we were to second-guess agency decision-making that is, in fact, intended to keep Americans safe? And how much longer would it take for these regulations, which...
Dude, the more I look at this guy, the more his fucking forehead annoys me. He looks like, Star Trek, a Klingon fucked a Ferengi or something.
in fact, are saving people's lives to go into effect, if they would ever go into effect, if the RAINS Act became law?
I think the concern is that they would never go into effect, and we'd be left with huge gaps in protection across every field of our economy. Although we might envision a system where Congress tried to legislate every regulatory detail, as you mentioned, there's a matter of comparative institutional expertise here, and agencies really have the expertise to bring that kind of science.
So why couldn't the experts write a law like they do with their decision making, bring that to Congress and say, hey, Congress, pass this? That's the way it was. If you believe in the alphabet agencies, that's the way it's supposed to work. Congress makes laws. Agency goes out, agency finds a problem, they write a regulation, they bring it to Congress, say, Congress, hey, make this into a law for us so we can enforce this. Congress passes it, boom, we got a law. Instead, they just write whatever they want and enforce it, a regulation that has the power of law. Unelected people just making the shit up as they go.
Scientific informed judgment to those regulatory protections.
And let me just end with a very specific example. During the Trump administration, the Federal Railroad Administration withdrew.
Here we go. It's all Trump's fault. Got to be Trump's fault.
An Obama-era notice of proposed rulemaking mandating 2 qualified crew members on most freight locomotives. Workers have strongly supported a crew size mandate like this one, as they believe it's integral to rail safety. Although the Biden administration has re-proposed this rule, railroads have staunchly opposed this safeguard. Under the RAINS Act, railroads would have even more leeway to influence rules like this one through lobbying members to use an unconstitutional one-chamber veto of such a rule. And so my question is, would the RAINS Act provide more protection for workers and people who use the rails and sometimes...
So in other words, he's saying since Congress is such a clusterfuck, we'll just let these agencies manage it however they want. Gay TF.
Less protection for hazardous materials that they transport, or less. In other words, would worker safety be impacted in a positive way or a negative way if the RAINS Act were in place?
Certainly in a negative way. We should be listening to those workers.
And with respect to the notion that the regulatory process is difficult to follow and doesn't have the voices of the American people embedded in that process, would you respond to that argument, Professor?
Sure. Under the Administrative Procedure Act, all agencies are required to have a period of notice and comment. Anyone.
Yes, they can have a period of no, comments and all this shit. But what did the ATF do when there were 100,000 people that wrote in and told them, hey, this regulation's bullshit, guys. We don't need this. They completely ignored the people who were against it and sent it out anyway. So the comments didn't mean a goddamn thing.
Any person can offer comments, and although there is room to bring even more voices to that process, agencies are required to respond to the significant comments that are raised and incorporate that understanding into their final rules. So there's very much a sense of participation and democratic accountability embedded in the process.
Thank you, Professor. I yield back, Mr. Chairman.
Ranking member yields back, and I now recognize the gentleman from Colorado, Mr. Buck, for 5 minutes.
I thank the chair. Ms. Ho, I want to direct these questions to you and I guess my comments also. We have a situation in Congress where we have a large number of programs that are unauthorized. The programs were originally set up with a sunset provision, typically 5 years. The 5 years has expired, and I want to just, there are actually 1,200 programs that have now expired, and Congress refuses to do its job and review those programs. When Congress pretended that it cared about spending, it set up a two-step process.
Yeah, Mike, they reviewed those. I can't remember how many comments they got, but there's no way they reviewed all those comments. If they had 2 people, 4 people, 10 people reading 24 hours a day with the number of comments that came in, it would have taken them over a year. Of course, they didn't review all those. All those comments against the frames and receiver rule, they did the same thing they did with pistol braces. They just told people to shut the fuck up, and they passed it anyway.
And the first step was to authorize a program, and the second step was to appropriate to the authorized program. The rules of Congress for the last 50 years have included a provision that requires Congress not to appropriate to an unauthorized program. What's so interesting about that is Congress waives its own rules for each appropriations bill so that it can bypass the responsibility of actually appropriating only to authorized programs. The purpose of this, obviously, is that Congress, as responsible to the American people, should be reviewing these programs, determining if these programs need to be expanded, contracted, amended.
Yeah, Mike, there was something like, there was over 250K, I think.
My question has to do with the interaction or interplay of the Chevron doctrine with the concept of Congress's responsibility in overseeing these particular programs.
Yes, thank you for that. Thank you for that thoughtful question. And I agree that the scenario that you lay out highlights, I think, one of the critical aspects, and why I think it's so important that we're here today having this discussion, is as to equal authority under the system that our founders designed, and that when Congress doesn't, we shouldn't be surprised to see other branches sort of exploiting that lack of action. So I think your question really highlights the important role that Congress has to
kind of screwy for a
in
second.
ensuring that our system of separation of powers that the founders bequeathed to us remains vibrant and effective in safeguarding individual rights and liberties. Thank you for that question.
And I have to say, I think that you are far too kind. You understand that you're testifying in Congress, and you are a gentlelady from the great state of Texas, and I respect all those things. But the reality is Congress has failed to do its job. And part of the problem and the reason for these administrative agencies overstepping their bounds, And the one that gets under my skin, and I'm sure my good friend from Wyoming, Ms. Hageman, would agree with me on this, is the WOTUS rule. It comes up every time the Democrats get into the White House, the waters of the U.S., and every time my district actually borders the state of Wyoming, and we share water. And if the Democrats get to regulate ditch water in my district, in every puddle in
Yeah, the Waters of America Act, like on the land me and my wife have, on the back portion of our land, there's a creek runs through it. It runs all down through this local area. Under the Waters of America Act, the government could come on my property anytime they want to get to that creek and tell me what I can and can't do anywhere around that creek.
my district, we're going to have problems. And so the idea that these
Matter of fact, they could take, if I wanted to take water from that creek and water a garden, they could tell me I can't take water from that creek.
agencies can expand their authority is really they are filling a vacuum that Congress has created. And my point, and I'm hoping to get your comment on this, my point is that without Congress's neglect, without Congress's failure to act, we wouldn't be dealing with the rain.
And yeah, I got just a few more minutes, and then I'm going to have to stop this and go pick my daughter up. We got a few more minutes though.
Act right now, because we would actually be doing our job every day of overseeing the functions in the executive branch.
Yes, Your Honor, I think the founders well understood and anticipated the very, I think, dysfunction you describe, which is it creates real problems in our system of separation of powers when one branch does not exert its lawful authority, does not do its job. And so for this branch, as you highlight, this branch's role in our constitutional form of government is to make law. And so when Congress does not, when Congress passes, say, vague laws, or when Congress does not act at all, it upsets the system of checks and balances.
I yield back. Thank you. The gentleman yields back. The chair now recognizes the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Mr.
Here
Buck's
comes
discussion
Nadler.
of the fact that Congress can't find the time to reauthorize all the programs leads me to wonder how Congress would ever find the time to go over thousands and thousands of detailed regulations.
Yeah, why
my
the hell
understanding is
should
that
we
under
have
the
to
RAINS
know
Act,
what we're
many
doing?
industries will be expected to self-govern. Professor Hammond, do you think the railroad industry will do this effectively, putting health and safety above profits?
No, there's a long and
Take it easy, Mike. We'll catch you after a while on something, I'm sure, brother. Have a good day at work.
well-documented history of a concerted effort by the entire industry to resist any safety requirements. The RAINS Act only makes it more difficult to actually put those protections into place.
In addition to the Dangerous RAINS Act, which we've discussed, members of the subcommittee also support the Separation of Powers Restoration Act, which would eliminate Chevron deference. That is, deferring to expert agencies on their interpretation of statute, so long as it's not unreasonable. Professor Hammond, do you think public health...
And who gets to define reasonable? The government is defining reasonable in these cases. And everything is reasonable to the government.
Health and safety would be improved or hindered if agencies lacked this deference and had constantly to go to court over their authorizing statute?
It would be much more difficult to protect the public. And I would like to just point out that I'm hearing the words Chevron deference, but the Chevron doctrine itself has a key component that this discussion so far has overlooked, which is the first step. If the statute is clear, the analysis stops. There is no deference to the agency because the clear language of the...
That's bullshit, because the definition of a machine gun is extremely clear in black and white letters, and the ATF still makes the fucking rules up as they go.
statute controls. It's only if there's ambiguity that is a matter of comparative institutional competence as between the courts and the agencies that a court should not be substituting its own policy preference for the way the agency exerts.
I think it's right at the end of this right here. I think you guys will see it.
Its expertise and did so with political accountability. So the Chevron doctrine itself.
Yeah, Waffles, you got me on that. Everything's reasonable to the government as long as it suits the government. You got me.
Has quite a bit more nuance and does recognize the expertise of agencies, but certainly has guardrails in place for congressional oversight.
Thank you. And I assume that if an agency abused its authority under the Chevron doctrine, that's subject to challenge in court?
Certainly.
Thank you. Supporters of the REINS Act argue that this bill would help tame inflation, despite the fact that the bill could, in fact, result in blocking any major rule contemplated by our expert agencies, even if they're designed to address inflation. Professor Hammond, how do you think the REINS Act, if passed, would affect the economy and inflation?
Well, we know. Are we okay there? All right. We know that regulatory protections actually help the economy, and I collected several examples in my written testimony, but just to give you one, EPA's proposed soot rule that was proposed earlier this year would save 270,000 lost work days. It would also provide $43 billion in net health benefits. That's good for the economy. If the REINS Act would cut off all of these protections at the knees, we'd see a lot of detrimental economic impact.
Thank you. The National Transportation Safety Board recently launched an investigation of Norfolk Southern following the derailment in East Palestine. The investigation is rare because it will consider Norfolk Southern as a whole rather than the East Palestine incident in particular. Professor Hammond, do you think Norfolk Southern is the only railroad company that needs more regulatory oversight? And do you think that regulatory oversight will be improved under the REINS Act?
No, and indeed, as I said previously, this is an entire industry-wide effort. And I should mention that self-regulation tends to be a euphemism for putting profits over health, safety, and the environment. We've seen that not just in the railroad industry, but for example, in the extractive energy industries. The REINS Act, once again, would only undercut the protections that we need.
And do you think this applies basically to every area in the economy?
Everyone that I've seen, including even the markets.
Thank you very much. Mr. Chairman, I yield back.
The gentleman yields back.
At the end of another question
one
session,
more
she says what I was thinking
of
about.
our members to take 5 minutes, and then we will vote. So if people want to go ahead and vote right now, we're going to recess immediately after Mr. Klein. So, and I now recognize Mr. Klein for 5 minutes.
Thank you, Mr. Chairman. I want to thank the witnesses for being here. I'm concerned by something that Professor Hammond said, that there's already a certain degree of accountability in the rulemaking process when, according to a recent study, the Department of Health and Human Services rulemaking practices from 2001 to 2017 revealed that 1,860 FDA final rules, 98% of their total, had been issued illegally, and that other agencies had similar problems in violation of Buckley versus Vallejo, where the Supreme Court held that rulemaking is a significant government power that may be exercised only by officers appointed in accordance with the Constitution's appointment clause. So what we have are unappointed, unelected bureaucrats issuing rules against the law, against the Constitution, and against court rulings. That's why I've introduced legislation called the Ensuring Accountability in Agency Rulemaking Act. It's a bipartisan bill. It says that all rules, except in limited circumstances, have to be signed and issued by an individual appointed by the president and confirmed by the Senate. It's common sense, it's compliant with the Supreme Court precedent, and it would ensure the accountability that the professor claims exists, but really does not at this point. You know, we have a situation where the Biden administration have the regulatory burden totals greatly exceed those of its immediate two predecessors. 517 rules have been issued, costing $318 billion in total and requiring more than 218 million hours of paperwork, not by bureaucrats, but by American taxpayers and businesses to comply with these regulations. So, as the AAF put it in their research, the overarching conclusions drawn from this data are hardly surprising. The Obama and Biden administrations imposed regulatory burdens in the hundreds of billions of dollars, while the Trump administration was nominally deregulatory. So in addition to co-sponsoring the REINS Act, we need to take action legislatively to regain the rulemaking power of the Congress. And I would go to ask Ms. Ho, let's go to another agency. The FTC, under Chair Lena Khan, recently announced a proposed rule that would purport to prohibit non-compete agreements nationally. This comes on the heels of California weakening or eliminating the enforceability of non-compete agreements, which China has capitalized on, and is another method in their arsenal to steal U.S. intellectual property, specifically trade secrets. Do you believe that the proposed rule exceeds the FTC's statutory authority?
Thank you for the question. Without commenting on particular rules, I will underscore that one thing your question highlights is that one way that we know or we can tell or suspect that an agency is exceeding its authority is when it acts in an area that it has not typically acted in before. That's one of the aspects of the major questions doctrine that has been, I think, a topic of interest lately. So where I think one clue perhaps that an agency may be acting outside of its authority is when it is acting in an area that it has not acted in, and also an area where in our system of federalism, states have typically acted.
What's your position on the constitutionality of rules issued that by non-confirmed individuals, essentially violating Buckley v. Vallejo?
I think that's an excellent question. I think I would need to know sort of more facts and circumstances to opine definitively. But I do think, again, your question highlights issues of accountability, accountability to voters.
Mr. Kleckner, I believe you spoke to Ms. Khan and the FTC a little bit earlier. Did you? Okay, can you speak to that? All right, Mr. Wolfson.
Yeah, I think that for the FTC to step into an area that they have never previously found authority in the FTC statute, to then say we now have the authority to bar particular behaviors, again, regardless of whether that is a good or bad law. You know, there are a lot of states, red and blue, that are addressing non-compete clauses. So regardless of whether or not that is a good thing, it's kind of like if Health and Human Services said we're going to regulate minimum wage requirements. It's not their bailiwick, and having them do it creates all sorts of problems. And regardless of the level of expertise of the people inside the agencies, it doesn't ever seem to be the case that the people who are at FTC would be the ones in the best position to evaluate those kinds of questions.
Thank you. I yield back, Mr. Chairman.
I thank the gentleman for his questions. We're going to take a short recess to vote. This is a special circumstance where there's only one vote, so members can go vote and come back quickly. So the recess, I anticipate, will probably be about 15 or 20 minutes, and we'll convene as soon.
Skip through this. We'll listen to, I think, probably about one, maybe two more guys. Come on, play, damn it. Okay, so I think Hank Johnson starts us off.
Republicans favor low taxes.
And my God, is this guy every fucking moron.
On the wealthy and less government. So low taxes, less government has been their campaign mantra since Ronald Reagan.
Yes. Well, that's been their campaign mantra, but they don't get it done. But ultimately, that's what people who are actually sane and have more than two brain cells to rub together want is lower taxes, less government, more freedom.
And to accomplish less government, just about every Republican, including those on this dais, have signed on to the Grover Norquist No New Tax Pledge. And in a 2001 radio interview, Grover Norquist revealed his true intention. He said famously, I'm not in favor of abolishing the government. I just want to shrink it down to the size where we can drown it in the bathtub, end quote.
Yes.
When Republicans are not cutting taxes, they're cutting the ability of federal agencies to protect the public health, safety, and the ability to enjoy freedom and prosperity. The REINS Act, which if passed, would prevent agency rulemaking from protecting the American public from corporate greed that jeopardizes the health and safety of the American people, is a move toward strangling the federal government.
With my own two
what the
hands.
REINS Act does is puts profit over people. Now, Ms. Ho, you, like the rest of America, observed the congressional dysfunction in its inability to elect a speaker. It took 15 rounds over a 5-day period. You witnessed that spectacle, did you not?
Yes, sir.
And the REINS Act would act as a chokehold on federal agencies' ability to promulgate rules that protect the health, safety, and welfare of the American people.
Because you're not
like those
protecting
in
the health,
East
safety,
Palestine,
welfare.
Ohio. Isn't that correct?
Yes, that's my understanding, Your Honor.
Now, there are some people in America who trust the federal government to make sure that our water is safe. All right.
And we call those people morons.
Air is safe to breathe. We rely on the regulatory system to improve our lives every day, whether that's by protecting working families from getting ripped off by banks or by ensuring that we have fewer car-related deaths. But in recent years, we've seen the devastation that comes from deregulation. Look no further than the disaster in East Palestine or the water crisis in Flint, Michigan. Congress can pass laws with broad outlines, but we need agencies to translate those laws into actionable policy, using input from scientists, stakeholders, and the public. These issues are complicated, and we need experts working on them, not members of Congress who get caught up in congressional gridlock and can't even elect a speaker. So, Professor Hammond, we're still discovering the fallout from the Norfolk Southern derailment in East Palestine, but we understand that residents are already affected by toxic chemicals that were released into the surrounding air, water, and land. Professor Hammond, will the ability of the federal government to create stronger environmental safeguards be helped or hurt by the passage of the REINS Act?
Thank you for that question. I believe it will be severely hurt. We need those environmental safeguards.
Why is that? Why will the REINS Act hurt?
It's because all of the effort that the agencies have brought to bear, as you mentioned, with scientific and technical expertise on actually evaluating how toxins do impact people's health and the environment, and then actually putting restrictions in place to prevent people's exposure to those. All of that kind of effort, which of course is also informed by a...
Did the whole thing freeze? It shouldn't have froze. Oh, shit. I got to get out of here anyway, guys. I got to load this up. I got to hit the bricks. Yeah, it looks like it completely froze up. All right, anyway. I'll try to play it again later. You perps take them easy. You be cool. Keep that thing on you at all times. And I'm out for the day, man. We'll catch you guys on another one later. Later, guys. Later 500. Later Waffles. Magnum. All you guys, man. You guys take them easy.